in the matter of SCAP and Solo Capital Partners and others, part heard.
Yes. Good morning, my lords. I was completing my submissions on the second part of ground 2. That is why we say that if we are correct that this is a civil and commercial matter, Dicey Rule 3.1 cannot be applied by the English courts. And I was on the point that in our submission it would be anomalous if the English court could refuse to consider the claim because of Dicey 3.1, when we say under the regulation the English court would be obliged to enforce a judgment on the same issue from the Danish court. Now, can I be clear about this? I do accept that under English law, Dicey Rule 3.1 requires the English court to refuse to enforce a judgment from abroad, a judgment which falls within the scope of the revenue rule or any wider Vasogo rule. There's no dispute about that. Our point is that under the regulation, the recast regulation, there is very limited scope for the English court to refuse to enforce a judgment which falls under Article 1. There's a public policy exception in Articles 45.1 and 46. That was the point I was making. But on reflection overnight, I do accept that this point adds little, if anything, to the main points which I was arguing yesterday afternoon. The main points being that Dicey Rule 3.1 is distinct from substantive defences like limitation or illegality for two main reasons, as I submitted. First, because Dicey Rule 3.1 addresses considerations very similar to those addressed under Article 1 of the regulation, which requires, as your lordships have seen, an assessment of whether on the one hand it is a civil and commercial matter, and on the other hand, whether it is a matter which raises public law issues of state sovereignty. And our main argument is that to apply Dicey Rule 3.1 would be to derogate from, render less effective, the principles which are applied by the Court of Justice pursuant to Article 1. That's the first argument. And the second argument is that even though, as Lord Gough said, Dicey Rule 3.1 is not a rule of jurisdiction, it is a rule closely related to jurisdiction. And I rely on what Lord Justice Simon Brown said in Franson. Lords, there's one other case which we suggest assists on this issue of whether the rules as to jurisdiction under the regulation have an effect on whether the English court can apply rules of public policy which go to justiciability. And I referred yesterday to the Supreme Court decision in the Lucasfilm case. Could we please go back to Lucasfilm? It's in volume 4 of the main authorities, PA4, and the court will find it at tab 27. And the court will see in the judgment for the court of Lord Walker and Lord Collins at electronic page 27, their lordships addressed the Mozambique rule of common law public policy, the rule that the English courts will not entertain an action.
Can I just, I'm sorry to interrupt you, but I'm having real trouble loading documents.
Is it just,
can I just try again?
my lord, or is it court generally?
It's probably just, there may be an answer. Thank you very much. Could you just tell me which
Yes,
page?
it's tab 27. We're looking at tab 27. We're looking at electronic page 27.
Thank you.
Mozambique.
And we're looking at what the Supreme Court said about the Mozambique rule of common law public policy. As your lordships know, the rule that the English court will not entertain an action for the determination of title to immovable property abroad, or the recovery of damages for trespass to such an immovable. And the court noted at paragraph 72 that part of the common law rule had been abolished by statute. And the statute provides, paragraph 72, the jurisdiction of any court in England to entertain proceedings for trespass to or any other tort affecting immovable property shall extend to cases in which the property in question is situated outside that part of the United Kingdom, unless the proceedings are principally concerned with the question of the title to or the right to possession of that property. So the common law public policy rule survives where the proceedings are principally concerned with the question of the title to or the right to possession of that property. Their lordships then address what happened in European law. There was a parallel development in European law, which also confirms broadly that the foreign land principle in the European Union is concerned only with actions to establish title. That development began with the Brussels Convention, and the Brussels Convention was then put into the original regulation. The effect is that the rule has been superseded as regards land in other member states by what is now Article 22.1 of the Brussels I regulation. It's now, things have moved on as the court knows, it's now Article 24.1 of the recast regulation. Their lordships then set out helpfully what that provision says. It provides that the courts of the member state in which the property is situated have exclusive jurisdiction, regardless of domicile, in proceedings which have as their object rights in rem in immovable property or tenancies of immovable property. The Supreme Court then said at paragraph 75, the Court of Justice has confirmed that what is now Article 22.1, now 24.1, must not be given an interpretation broader than is required by its objective, and that actions for damages based on infringements of rights in rem or on damage to property in which rights in rem exist do not fall within its scope. In other words, the primary jurisdiction rules based on domicile do apply in relation to a claim for damages, and European law does not contain the residue of the common law rule that survived the legislative change. 76, the consequence is that in the United Kingdom, the trespass aspect of the rule has no application as regards land in other member states, and subject to the controversial question of the applicability of Article 2, it's another issue, can only apply to land outside the member states where a question of title is involved. So, in an action for damages in respect of trespass to French land, the English courts could not apply the common law rule to decline to adjudicate the merits of the claim, even if the proceedings are principally concerned with title or possession. The Supreme Court was recognising in those paragraphs that a rule of English law public policy is displaced by the provisions of the regulation. And the reason why a rule of English law public policy is displaced is because it is, in colloquial terms, shooting at the same target as a provision of the regulation. And the Supreme Court returned to this matter later in the judgment of Lord Walker and Lord Collins for the court at paragraph 98, which the court will find at electronic page 33. And paragraph 98 addresses the Court of Appeal decision in the case of Pierce. And the court helpfully summarises the position. Mr. Pierce was claiming that the defendants had infringed his English and Dutch copyrights in his drawings and plans for a town hall by copying them in designing the Kunsthal in Rotterdam. There was no issue about the existence or the validity of the copyrights. The sole factual question was whether his drawings and plans had been copied. On the question of the justiciability of the claim for infringement of the Dutch copyright, the court had personal jurisdiction over the defendants by virtue of their domicile in England, and there's a bit of detail about that. It's not suggested what is now Article 22.4 applied. And then this, the effect of what is now Article 22.1, now Article 24.1, was that the common law rule no longer applied within the member states, and that where proceedings in relation to intellectual property fell outside what is now Article 22.1, that's Article 24.1, the general rules of jurisdiction applied, and then this, and there was no room for an objection of non-justiciability. And that's the point. We say that these paragraphs in Lucasfilm, paragraph 76 and 98, establish that where the Convention on Jurisdiction addresses a specific topic, there can be no room for a rule of English law public policy as to non-justiciability, which addresses a topic addressed within the Convention. And I've made my point, and I'm not going to repeat it in detail. I've made my point that we say that the regulation by Article 1 does address the topic of whether a claim is on the one hand a civil and commercial claim, on the other hand a claim which is in truth a public law claim that addresses matters of sovereign powers. And the former is within the jurisdictional rules, the latter is not. We say it follows that English law cannot apply its own public policy rules as to non-justiciability on that subject so as to decline to consider the merits of the claim. That's what we rely upon in Lucasfilm. My Lords, unless I can assist further, those are the submissions I wanted to make on grounds 1 and 2. As advertised, my friend Mr. Feely has some further submissions for SCAT on further matters. My Lords, we've agreed with the respondents that as we are now going to finish our submissions before our deadline of 11:50 this morning, that saved time should not be added to the respondent's time, but should be available if needed for our reply, although I am very well aware that the court will be best assisted by an efficient reply, not one that goes on and on. I'm well aware of that. Those are my submissions. Thank you very much for your patience with us.
Mr. Feely, what would be of great assistance to the court is to have some clarity on why ground 1 is not pursued against ED and F man.
My lord.
You take your own course, but that's one of the questions that obviously we have been concerned about.
Well, my lord, let me address that first. We have taken the pragmatic approach of focusing our appeal on what we say is the most important issue that arises in this case, namely a fraud claim against the respondents to ground 1. We sought to simplify the appeal by not pursuing ground 1 against EDF and man, against whom we make no allegations of fraud. Similarly, my lord, the foundation of the case against the ground 1 respondents, namely that there were no shares, there was no dividend, there was no tax, is not a submission that can be made with the same force or without qualification as regards EDF and man. The case against EDF and man is of some complexity relative to that pursued against the Solo, etc. applications. Now, my lord, I'm happy to go through the EDF and man case to explain what's involved and how we put it, but we have essentially taken a pragmatic course. We've taken what we consider to be our best and strongest points.
Is that because there were shares? There were shares in the ED and F man?
There were, in some respects, my lord, we do not allege there were no shares, and it certainly appears that there were some shares. So we're not in a position to assert, and we do not plead a positive case, that there were no shares. In some respects, in respect of what is known as the Annex E applications, which accounts for about 20% of the applications made to us under EDF and man, it's admitted that there were no dividends, that no dividends were received. And we obviously plead that is the case. But we have not had full disclosure from EDF and man, and our pleaded case dates from the winter of 2019. So we have not advanced in our pleadings a positive case that there were no shares. So that's an important difference between the case against EDF and man and the case against the respondents who are the subject of ground 1.
So when you say you've taken a pragmatic view, what you are avoiding is an argument about whether or not having shares is sufficient to bring you within DICE 3, namely that it makes the difference between the fraud claim and a claim where someone has shares but makes negligent misrepresentations about ownership and so on and so forth.
That argument does not arise on ground 1 as we present it.
So exactly, and so what you are pragmatically avoiding is hours or days of argument in this court about whether if you've got shares, never mind the rest, you are enforcing it changes the characterization of the transactions.
That argument does not arise in ground 1 as we put it to the court. It is on our case as alleged against the ground 1 respondents. That is not the case. And I should add, my lord, the case against EDF and man in terms of the quantum of damages we claim is approximately 5% of the total value of the claim. So although it in many respects is an important aspect of the case, it's a very small aspect of the case quantum-wise.
But for the purposes of ground 2, do we proceed on the basis that the ED&F man transactions do fall within DICE Rule 3?
Well, my lord, that is not a concession that we make, but it is, we do not challenge the judge's conclusions on that front, in the sense that we have not included them as a ground 1 respondent. But we have taken...
Correct me if I've misunderstood your answer. I think that means that the answer to my question is yes.
You don't formally accept it, but it's an inevitable consequence of not having appealed the judge's judgment.
We're bound to treat EDF, sorry, I'm over-talking again, but we're bound to treat the EDF man transactions as falling within DICE 3 in this court for this appeal.
That, my lord, that inevitably follows from the position we have taken on ground 1, but it's not a formal concession that we make.
But I'm sorry, maybe my lords understand that more clearly than I do. I understand that to be a concession for the purposes of this appeal, whatever may happen later. And I can understand you're reserving your position to argue differently in some other court. But for the purposes of this appeal, I understand that to be a concession. Am I wrong?
Well,
That's why we asked you the question in the first place, because we wanted to understand what the logic was for not running the same arguments against EDF man as you're running against Solo. And because I think one of the things that's said against you is that there's an inconsistency here, which demonstrates that, ingenious though the argument is on ground 1, it can be demonstrated to be incorrect. Now, we're not expressing any views one way or the other at this stage, but there obviously is a distinction being drawn by the appellants between the position of the Solo respondents on the one hand and the EDF man respondents on the other. We just wanted to understand why that was.
well, I've endeavoured to explain to you, my lord, why we've taken, we suggest, is the approach that appellants should take, namely taking their best points and focusing on the simplest case that they can advance in this court.
Yeah, sorry, we rather took you out of your stride there, I'm afraid.
Well, my lords, I was proposing, and I don't want to take the time to do that if it's not of any assistance, to outline how we put our case against EDF and man, given that that was a point my lord yesterday morning raised. And in very broad summary, the claim is one for negligent misrepresentation and for restitution for unjust enrichment. And the claim is most conveniently outlined by reference to Schedule 5T of our particulars of claim, where we plead the case against EDF and man. Now, the reference to that in the bundle is Core Bundle 1, tab 8.1, paragraph 1. Do my lords have that?
Yeah, re-amended Schedule 5T.
That's correct. My lord, if I can just take it by reference to the document, we begin effectively at paragraph 3, where we allege that in or about 2012, EDF and man devised and structured a scheme to enable it to profit from the making of apparently eligible withholding tax applications to SCAT and SCAT's acceptance of the same. And then in paragraph 4, we outline in broad terms what we say the scheme involved, namely the recruitment by EDF and man as clients of US and Canadian pension plans. It involved EDF and man acting as custodian on behalf of the pension plans. The scheme further involved EDF man purportedly purchasing shares in Danish companies and concluding or procuring a series of transactions purporting to vest beneficial ownership of the shares of the pension plan over the reference date, with the shares being sold shortly thereafter. These transactions were to be entirely financed by EDF and man, with no funding provided by the pension plans. The only purpose of the scheme was to enable EDF and man to produce tax vouchers to be used to make withholding tax applications to SCAT on behalf of the PPs and to reduce SCAT to make payments and reliance on the same. And then, my lord, in paragraph 6, if we can ask the court to turn on to page 2, we refer to tax vouchers. From September 2012 to May 2015, EDF and man purported to implement the EDF man scheme. EDF man produced 420 documents expressly entitled tax vouchers on behalf of 36 pension plans. And then moving on to the next page, paragraph 8, each of those tax vouchers was presented to SCAT as part of an EDF-MAN application, and in response SCAT paid out an aggregate sum 582 million Danish kroners. And just pausing there, I should explain what we mean by an EDF-MAN application is essentially an application for a refund which is based upon the tax voucher document produced by EDF and MAN, which I'll come on in a moment to say what.
Though the application may be made by someone else, it will be made by someone else. The actual application is made by someone else.
That's correct, my lord. And then paragraph 9, we make some allegations relating to the tax voucher. We set out in paragraph 9 what it expressly provided. We, EDF-MAN, confirmed that the relevant pension plan was holding the below securities over the dividend date. EDF and MAN has no beneficial interest in the holding and will not be reclaiming tax. The dividends specified in this credit advice note were paid net of withholding tax to the relevant pension plan. And then paragraph 10, we say each of the tax vouchers contain the following express representations, and namely that the specified numbers of shares in the Danish company were held on the reference date, that a specified dividend had been received for the account of the named pension plan on the identified pay date and in the specified amount received, that such dividend had been received on behalf of the named pension plan, net of a specific amount of tax that had been withheld by the named Danish company which had been suffered by the pension plan, and that EDF-MAN did not have a beneficial interest in the relevant Danish shareholdings. Now, it's admitted that that information was contained in the tax voucher, albeit that it is disputed and that it was a representation in the legal sense. And then paragraph 11, we allege an implied representation that the relevant pension plan was the beneficial owner of the specified number of shares in the named Danish company and the beneficial owner of the amount received by way of a dividend net of the withholding tax. Now, my lords, if I can ask you to turn on to paragraph 15 on page 5, where we allege duty of care and negligent misrepresentation. We say we paid out some 574 million kroner in reliance on these vouchers, and that a duty of care was owed by EDF and MAN to avoid causing loss to SCAT due to inaccuracies in false statements of the tax voucher. And my lord, the allegation of falsity is made at paragraph 18, which is at page 7. Now, the allegation of falsity can be taken in two parts. Firstly, my lord, there are the so-called Annex E applications. These are 80 tax vouchers which were used to make reclaims to SCAT of some 184 million kroner. Now, we call them Annex E tax vouchers because they are identified by EDF and MAN at Annex E to its amended defence of September 2019. And the reference to that is CB2 10.3, page 65. Now, I don't think I need to turn up Annex E, but in summary, EDF and MAN admit in their amended defence that the information in the relevant 80 tax vouchers was false, that the pension plan had not received the amount set out in the tax voucher by way of dividend and had not suffered with the withholding tax claimed. Now, slightly more complicated because within Annex E, within those 80 tax vouchers, 64 of them, in the case of 64 of them, which financially wise is the vast bulk of them, EDF and MAN admits that no dividend at all was received and that no tax at all was withheld. And SCAT paid 161 million kroner in response to those documents setting out entirely false information. Now, since the pleading was settled in the winter of 2019, in a letter of January 2021, EDF MAN's solicitors have told us that in respect of these transactions, the Annex E transactions, its client's counterparty in the trades, purportedly underlying the Annex E transactions, was a related EDF MAN company, namely EDF MAN Proprietary Trading Dubai Limited, and that EDF MAN Dubai entity was in fact short selling, that it did not have the right to the relevant shares on the trade date, it had not received a dividend, and correspondingly its purported client had not received a dividend, albeit, they say, that it had received an equivalent amount to a net dividend, albeit from EDF Dubai, not from a Danish company. Now, certainly, we would say as regards those shares, on the basis of that letter, and I have to accept it's not in the pleading of the winter of 2019, there were no shares in the sense that they were buying from a naked short seller who was not able and did not settle by means of delivery of shares, but instead handed over what is known as a manufactured dividend, a sum of money equivalent to what would have been the net dividend received from the Danish company. Now, as regards the other applications, the remaining non-Annex E applications, as we've rather inelegantly called them, we plead at paragraph 18E, and you find this on page 8, that we plead falsity in the sense that the relevant pension plan did not hold and was not the beneficial owner of the specified shares and had not received any dividend as beneficial owner of the withholding tax. Now, we have not alleged a positive case as regards the non-Annex E shares that there were non-Annex E's applications. There were no shares, but we have said in Roman 1 and following that to the extent that there were shares purchased and the relevant pension plan held any interest in those shares or received any payment by way of dividend, it did so for the benefit of EDF and MAN, and in a practical and commercial terms, EDF and MAN benefited from the receipt of any dividends, if which is not admitted, EDF and MAN received any dividends. Now, and then in paragraph 19, we plead a breach of the duty of skill and care by EDF and MAN in making the representations that we say were made in the tax vouchers. And then at paragraph 21 on page 11, we plead reliance and loss as a consequence of that. Lord, that is the case, an outline of the case as pleaded against EDF and MAN. I'm obviously happy to answer any questions that arise out of that. Unless I can be any further assistance to my lords on this aspect of the case.
Is it any part of, I've read the ED&F MAN defence. Is it any part of your case to say who in fact owned the shares or whether a dividend was declared on the shares and withholding tax withheld? I know you say that so far as ED&F MAN is concerned, it was a manufactured dividend in the way that you've explained.
Annex E, yes.
Yes. But is it any part of the case that we need to understand who in fact owned the shares and or whether a dividend was declared and or whether withholding tax was withheld?
Well, my lord, if shares were held and if a dividend was received on the contingency that we pleaded,
It wasn't by the EDF MAN?
the dividend and the shares were beneficially owned on our case. And we set this out at page 8 of the document, Roman E. The case is EDF MAN itself was the beneficial owner of the dividend and was the beneficial owner of the shares, but was not on, and it's common ground, I think, that on its case, its clients were the persons liable for any tax due in respect of any dividend as the recipient of those dividends for the purposes of Danish tax law. But on our case, on the alternative case which is pleaded in Roman E, if and to the extent there were shares and there was a dividend, then we say that EDF MAN, rather than the pension plan, was the beneficial owner of the shares and of the pension plan, of the dividend. That's Roman Roman 2 on page 8.
Thank you.
Thank you, my lord.
None of this matters anymore because you're not, unless you succeed on ground 2.
That's correct. The purpose of this
Well, if you don't succeed on ground 2, then the whole case against ED&F MAN falls away, doesn't it?
judge's order stands.
because it's covered by Criteria Rule 3.
Yes.
So you're saying, I think it's very plain, but you're simply saying that the judge was only wrong in relation to fraud claims. That's your position on the appeal.
That is the position on ground 1 that we have advanced with this court, yes. We're not advancing a case further than that on ground 1.
But the basis of the argument there, which is that there was no tax, applies equally where there was no tax.
Yes. And the case we advance against the ground 1 defendants, as well as being a case of fraud, is predicated upon there being no shares. That is our case of fraud. There were no shares, there was no dividend, there was no tax. And the contrary was represented to us dishonestly.
Why does it matter? Why does it matter whether the representation is fraudulent or not, if there were no shares and there was no tax? On your argument, I'm not sure why the argument on ground 1 is dependent on it being fraud.
The argument in ground 1, my lord, is in response to the way the judge put it, namely that a fraudulent application gives rise to a tax relationship, is answered in my submission and our submission by saying it was a fraudulent application made with the intention and effect of inducing us into treating these applicants as taxpayers when they were nothing of the sort. And that's why we say it's important. Unless I can get any further assistance, my lords, those are the submissions I wish to make in this aspect of the case.
Thank you very much, Mr. Feely. That's very helpful.
Thank you, my lord.
Yeah. Right. Yes, Mr. Jones.
Lord, good morning. And personal thanks to the SCAP team for coming in admirably on time, so no one's going to be under pressure. Well, as you know, the respondent groups have coordinated their approach both to written and oral advocacy
Yeah.
in a way that will fit into the timetable and allow each of the groups to express their own views on the key points arising on the appeal in their own way. So when Lord Justice Mayles directed that we be lead respondents for the purposes of the skeleton arguments,
Yeah.
Your Lordship would have seen all the
Yeah.
thank you. Your Lordship would have seen all the directions about skeleton lengths and so on and so forth.
Yeah.
He made no direction that we be lead advocate today, and I am not fulfilling that role. So the reason I make that clear is because I'm not speaking on behalf of anyone other than my clients, and those who follow me should feel free to agree with me or disagree with me as they see fit. That said, we have, as you would have expected of us, done our best to coordinate, and we will come in on time. So that is important.
How you divvy up your time is a matter for you, but the one thing that I think I'd say on behalf of all three of us is that we would expect, it's not a question of what we expect, we do not want repetition.
Lord, I understand that. I think your Lordship may find, as you've seen of the skeletons, that similar issues are dealt with in slightly different ways.
I'm just making
saying the same
laying down
things.
a marker, Mr. Chancellor, that,
Lord,
in other cases, and I appreciate this case involves an enormous amount of money, but in other cases, I think there might have been a direction from the court that there was one respondent that dealt effectively with everything.
Lord,
and
that
everybody else just had to tag along.
Lord, that I entirely understand, and because your Lordships have allowed us and not to be constrained in that way, I thought it right to say, especially for those listening and those abroad listening,
Yeah, absolutely.
that I'm not speaking for everybody and don't purport to.
We understand.
I'm pretty confident that your Lordship will not hear repetition of the type that you would not wish to hear, but you may hear numbers of us dealing with issues in our own way. From Lord, that's what I wanted to say by way of introduction. Now, we've divided our efforts between Ground 1 and Ground 2.
Yeah.
So, while we may not be as precise as this in practice, we've assigned 4 hours to Ground 1 and 3 hours to Ground 2, very broadly.
Yeah.
Now, I'm speaking first on Ground 1, followed by Ms. MacDonald for the DWF defendant, then Mr. Beale, who was instructed by my clients, but who has taken Mr. Baker's place from the trial level as being the only specialist tax counsel who's going to address you. And then finally there will be Mr. Zellick, who will address the court for the Norton Hugerworth respondents. Now the DWF defendants, just to remind your Lordships, are not concerned on Ground 2 at all. So their fate is determined by Ground 1. The majority of my multiple clients, the Sanjay Singh defendants,
Not faced in Ground 2 because they're simply not within the European
Correct.
Union.
absolutely correct. The majority of my clients are only concerned with Ground 1 for the same reason.
Yeah.
But we have a handful of European companies who are also then interested in Ground 2. We've elected not to address the court on Ground 2, reflecting that emphasis for us between Ground 1 and Ground 2. We're entirely content to leave our fate in the hands of Mr. Malik, who as we've just established, is only now a Ground 2 player. I'll come back to that in a few moments. Mr. Palmer for the SMB defendants, and again Mr. Zellick. So you will be hearing last in line of each of the two teams from Mr. Zellick twice. But his arguments will be very distinct, as your Lordships will know. Now, I have a few submissions to make about legal principles as I go through, but largely I think we hope that will fall to Ms. MacDonald. That's, in a sense, the division we've established between us. Tax will fall to Mr. Beale. Mr. Zellick will be making his own submissions on key points, and he may be the one with sufficient time to, if I may be so bold and not be rude in any way, but who will try and unpick what we think Scat's position on EDNF Man in Ground 1 now is, following Mr. Phillips' submissions. So I think he'll be following up on that as well. I'm going to touch on it, but I'm not going to try and get into it in too great a detail because I've only just heard what is said, and I too would like to reflect on it. Speaking for myself, if I may just make a passing comment on that topic, I can see no alternative to your Lordship's proceeding on the basis that the claim against EDNF Man is indeed caught by Dicey Rule 3. Scat can't dodge that bullet. Whether it is effectively a concession, expressly a concession, or withheld from being a concession, I think makes no difference.
It doesn't make any difference at all. It's an aspect of the underlying judgment which is not challenged on appeal.
Correct.
And therefore the Court of Appeal has to accept that the judge was right on that point,
Yeah.
even if we formed the view, I'm not saying we have or we will, that it was completely illogical.
So, Lord, I mean, no disrespect or criticism of Mr. Feely, there might be all sorts of reasons why he doesn't want to commit himself or his clients today, but in a sense, as I say, it just simply makes no difference. So I don't make that submission arising from his want of express concession. It makes no difference to that. There is just one point I'd like to pick up, however, and I'll do it now if I may, as it's fresh in your mind, and that is the suggestion that there were no shares, and I just want to, as it were, understand that we're all on the same page in relation to that. Because if it's being said that there were never any shares, that seems to be on the face of it to be completely wrong and completely contrary to the basis upon which the trial proceeded. And your lordships may be assisted just by looking at an exchange. And if we could put up on the screen, please, SB2, Supplementary Bundle 2, tab 1818, and go straight to page 5 of that. So SB2/18/5. Well, I'm going to pick this up very quickly, and I'm not going to read it out. I'm going to invite your lordships to read it because that will be quicker. But if you go to the right-hand side top page, so numbered 15 at line 12, and you pick up words from Mr. Baker, Queen's Counsel, and if your lordships would just read that paragraph and the first 5 lines of the next page underneath it. Lordships have read that. I'm sorry if I'm going too quickly. If your lordships then pick up Mr. Justice Andrew Baker at line 11 in the page underneath.
Yeah.
Can
we go down? Yeah, thank you.
Yep, thank you. Wait for your lordship to indicate when we should change page. Over to page 6, please. Thank you. And if your lordships could just read page 17 and the first couple of lines of 18 underneath it.
Yeah, well, I think that's certainly my understanding of what Lord Panic told us yesterday.
I'm grateful. It was also, it was being put on the basis that
There were companies, there were Danish companies which had shareholdings, and dividends were issued. The withholding tax was withheld.
Yes.
But the people who then, or the applicants, your clients, then came in, as it were, on a fraudulent basis and pretended to be
the question.
The people who were the taxpayers who were entitled to claim the refund. I mean, that was the case as we were told yesterday.
May I ask the operators, just so we can see the bottom half of this page, because you'll see the issues that arise so far as Mr. Baker was concerned. There's a passage beginning, yes, it's now there, line 7 on page 18, beginning, yes, but it must follow from that. So if you've just read that one paragraph then of Mr. Baker, Queen's Counsel, I needn't ask you to go further than that. That will, I hope, serve as a suitable introduction to what I will come on to in a few moments, is to tell your lordships of that which you will have read, but I can just give it some flesh on the bones, if I may, as to the way in which we ended up with 3 trials, or possibly 4. There was a remedies trial to follow, but we ended up with the first 2 preliminary trials. One was the revenue rule trial, and the second was going to be validity. And validity was designed to investigate whether the trading patterns and models that were undertaken were, in the broadest sense, valid and lawful. Hence, it got the expression validity. That was the purpose of that. I'll come back and explain that in more detail, if I may, in a few moments. Now, your lordships know, therefore, that there were 7 stages planned, I think, in the judgment of Mr. Justice Andrew Baker, 7 stages to the trial, or the dispute. Validity trial was due to be heard in October 2021, but that was vacated as a consequence of the result on the revenue rule trial. Now, the judge, we respectfully submit, identified Dicey Rule 3 as a part of the substantive English common law, and that it was not a rule of jurisdiction. And as Lord Panic has already traversed yesterday, some older cases speak in terms of jurisdiction, some speak in terms of justiciability. Lord Gough described it in terms of judicial self-restraint. But can I just invite your attention to where Mr. Justice Andrew Baker ended up, and that's his judgment, paragraph 148. I think your lordships are possibly all working off physical copies of that, but I'll give you a bundle number in case you need it. It is CB 1/3/42. And he reviews some of the language that I've just summarised: judicial self-restraint, rules of non-justiciability, and so on. And what he then says in line 5, labels ought not to be determinative, but for what they may be worth, I prefer admissibility. English law is a mandatory rule of the lex fori, overriding ordinary choice of law rules, does not admit claims that are in substance attempts by a foreign sovereign, directly or indirectly, to exercise their sovereign power through the English court. So, Lord, I may find myself using the word admissibility, and during the course of my submissions, I want you to know where that comes from. That comes from paragraph 148 of the judgment. So the central question on this appeal is how to go about the characterisation exercise.
I mean, in a sense, it's how many angels can you get to dance on the head of a pin? Because one way of looking at Lord Gough's analysis would be to say, well, the court has jurisdiction, but the court isn't going to exercise, it's going to exercise its discretion not to exercise the jurisdiction because claims of this sort are not admissible. It's the same point.
I don't think the language makes any difference, but I've adopted in my own head admissibility.
No, I'm not criticising. I'm just saying it's really all the same point.
I don't read any of those for this purpose as saying anything different, and I don't think by making that submission I'm saying anything relevant to ground 2.
I think all one needs to keep in mind, I suppose, is it is common ground, that it is not a rule of jurisdiction as such.
Correct. Lord, I respectfully agree. So we then embark on the characterisation exercise, which the trial judge then undertook. And I don't think anyone would say that is a particularly easy process. But it's assisted in a way by a point that I think Lord Justice Stuart-Smith was adverting to in one of his first questions yesterday morning to Lord Panic. It rather depends how you frame the question and when you start asking the question as to how the characterisation exercise might be answered. So a lot of what the defendants and the respondents are going to be saying, I think, is really addressing that point. In other words, what goes into the basket for the purposes of your and the court's characterisation exercise. Now, in very quick order, can I invite you just to look at the what I'm going to call the principal pleading, the one that concerns me, and we'll find that at CB1 tab 18, 18. And if you go, please, operators, to page 10 of that document.
CB1 tab 8.
CB1 tab 8, page 10. And I'm quite sure your lordships will have read this, but it may be useful just to come back to it at this stage and remind you of what the entire case against the Sanjay Shah defendants and effectively all other defendants other than EDF Man amounts to. But I'm only speaking for the SSDs. If I've overstated that, it matters not. So I'm going to invite you just to read to yourself, please, 3 paragraphs. Paragraphs 19, 21, and then 23. I'm guessing your lordships may have got to the end of 2019 by now without breaking your concentration.
I'm waiting for the presenter screen to move on.
Oh, I'm so sorry. My lord, I wasn't watching. I beg your pardon. Could we, I'm sorry, pick it up the previous page, page 10?
It's at the bottom of the page.
Yeah, but if we start I don't think your lordship had even seen paragraph 19 at that stage, had you? Had you started paragraph 19?
Yes, I was waiting for it to go to page 11.
I'm sorry. Then go back to page 11. Forgive me, I hadn't appreciated the problem. There we are. Yeah. Lord, by the time you've reached 19, you know that there are 4 representations falling in that basket. When you read paragraph 21, you will see that they are crafted slightly differently simply because they affect different status, but they are effectively making precisely the same points. So if we could go to the foot of that page 11, please, thank you. Change of page at this stage will not inconvenience anyone. So can we now go to page 12? Let your lordship see the end of 21. You'll note, please, the definition established in 22 and 23 that follows. I'll may come back to this in due course when describing how the causes of action emanate and spread out from that. But take it from me, if you will, for the moment, that those 4 representations in reviewed in 23, which are said to be false, are the core of the entire pleading. Every cause of action, I'll make that good if I have to, but the trial judge accepted it, it's never been challenged. Every cause of action relates back to those 4 core points. Three of which relate exclusively to what I'm going to call validity matters, generally. They relate to the trading, patterns of trading. They relate to the status of those who applied for the WT applications. They relate to how those applications were treated by SCAT, the tax agency, and the assessments and decisions that SCAT took in order to make the reimbursements. Lord, it is useful at this point just for me to say there are, in my submission, 7 stages of the process which one has to bear in mind for the purposes of this case. 1 is the dividend tax imposed, with the mechanism for collection initially through payments to SCAT by Danish public companies. So that's the creation and imposition of the withholding tax. The second stage is the payment by the relevant Danish companies of that withholding tax, which, as is manifestly obvious, is a temporary stage only, as the trial judge established, then awaiting to see what, if any, reimbursements of all or part of that withholding tax would appropriately be sought and made.
So it may be temporary, but it may not.
Correct. Yes, it's not known at that stage. SCAT wouldn't know at the point.
It's not known whether it will be challenged in any way.
Well, it's not a question of challenge, Rod. It's simply a question of whether an application will be made under a relevant DTA by anyone.
Yeah, if all the shareholders were Danish, then the chances are that there wouldn't be any applications, because they will have to pay Danish taxes pursuant to the Danish tax regime, and the relevant tax is 27%.
Well, I'm not going to make a formal concession about that because I don't know enough about Danish tax, but in principle, your lordship must be absolutely right, if I may say so. Yes, I'm going to assume for practical purposes that that's absolutely correct, but I can't myself speak for the Danish tax system domestically. So when I say temporary, there is a system in place for people to make WHT refund claims, and until such time as that has occurred, the tax take, so far as the Danish fisc is concerned, is on a temporary footing. The third stage is the making of applications by WHT applicants, let's call them. The fourth stage is SCAT's consideration of those applications and its decision by way of its tax powers assessment as to how much tax is due to be repaid, if any, and how much tax it will retain, if any.
Was that all part of 4, or was that?
All under 4. 5 is when SCAT then pays out money to the applicants it has approved by its, we would say, sovereign decision-making powers. And the necessary consequence of that is that because the way withholding tax works, SCAT will have made a decision that applicants would have paid too much tax initially. 6, and this then gets into the interstices of this claim. 6 is when SCAT makes an administrative decision to rescind its earlier decision to refund, and I'm going to take you to a document or two to show how that happened. And then 7, we get a claim which is to seek recovery of the allegedly overpaid refund. And while I don't suggest that there is any science in my 7, addressing, I hope, a way, in an appropriate way, or Justice Stuart-Smith's initial question yesterday, those are the issues which form the basket of points that we have to consider, we respectfully submit, in order to undertake the characterisation exercise. Now, a little bit of background about the case, if I may. It launched in 2018. Some, but not all, defendants took the revenue rule as a defence. That process took us through to mid-2019, when we convened a 3-day CMC in January 20. At that stage, no one had suggested any form of early disposal of the revenue rule issues. The engine for that was the trial charge. Everyone at that stage had assumed a single trial would take place. The judge raised the question of whether it made more sense to the court and the parties to look at preliminary issues to resolve matters in a sequential way. And at that stage, he identified certain possibilities, January 2020. My recollection is that he identified revenue rule, questions of validity, and trading patterns, and whether there were false representations, i.e. misrepresentations, had been made. And he charged us all to go away and see what we could agree between ourselves, and that's why you ended up with, eventually, the preliminary issue judgment, as we're calling it, following a reconvened CMC in July 2020. Now, the approach taken by SCAT, as I recall it, was to continue to oppose any interim decisions. I'm not critical of that. The good case management decisions for all of us to make as to how best to go about it. The principal defence teams had concluded by that stage, quite firmly, that we could not deal preliminarily with the question of misrepresentations. The judge accepted that, and that fell away, which is why we've ended up with revenue rule and validity.
It would be certainly in a case of fraudulent misrepresentation, pretty odd to proceed on as it were, an assumed factual basis.
Well, I think the question was whether we could get to misrepresentations, in other words, falsity without the dishonesty element. Whether that was a suitable way of dealing with it, and we all concluded it was just too difficult to draw a sufficiently thick black line, frankly, between those two. I'm convinced we were right about that, as everyone else is, I think.
Yeah.
Now, SCAT said no one had applied to strike out their claims, therefore we didn't have any confidence in it, therefore it was all an irrelevant point, essentially. You'll see this reference in the judgment, because the judge said, well, SCAT didn't apply to strike, we didn't apply to strike out the claim, and SCAT didn't apply to strike out the relevant parts of people's defences. So he then said he wanted to convene a preliminary trial. Now, although you've seen reference to his paragraph in the judgment in July of 2020, and Lord Panic took you to it, it wasn't structured as a strikeout application by anybody. It was structured as a preliminary trial. And I want to spend just a few moments, if I may, investigating with your lordships what that has given rise to, because it's relevant to the meaning you give to the two words "as alleged" in the formulation of the preliminary issue, which was then directed to be tried. So, your lordships will also possibly have seen, but not studied, I'm sure, because you weren't asked to, I don't think, the matters that were going to be dealt with at the validity trial. And if you wanted a reference to that, I'm not suggesting we turn it up now, but if you want a reference, it's SB1, tab 9, page 18, 18. But a cursory glance of those will show that the validity trial was going to deal with the trading structures, the transactions which had given rise to the trades, and the lawfulness and validity, in effect, of the applications that were made. Therefore, everything in relation to representations 1, 2 and 3 in each set of 4 that I've referred you to in paragraphs 19 and 21 of the 4A book. The judge was anxious to see whether either of those preliminary trials would be dispositive, this is a very important point, and I'm going to spend just a couple of minutes on it, if I may. He wanted both trials to be dispositive, if possible. So far as the validity trial was concerned, he was persuaded, I think by Mr. Feely, that it would not be dispositive, because even if we succeeded on the validity issues, which went to representations 1, 2, and 3, the trading misrepresentations allegedly, there would still be a claimant who wished to go to trial on representation 4, on fraud. And I have to say, I remember this relatively clearly, because I did venture the suggestion that I thought it would be quite difficult for somebody to go to a fraud trial on the basis of the allegedly dishonest implementation of an entirely valid and lawful scheme, which struck me on the face of it as being something of a tall ask, if I may use that expression, but that was Scott's position. Well, it wasn't, and the judge accepted. The judge accepted that he couldn't therefore.
How can that run?
Well, I don't think it could.
If it's a legitimate scheme,
Well,
how can there be fraud about it?
well, I suppose it's technically possible for you to do something in the belief you're doing something entirely unlawful, but unbeknown to you, it's entirely lawful. So you could, I suppose, but your lordship is
novel course of action.
Well, look, but Lord,
Well, you think you're defrauding somebody?
yes, but you're not. You're not. No, Lord. Yes, Lord, I'm not going to try and say why that was a particularly good idea, because it wasn't my idea, and I did poke a little bit of fun at it at the time, if I recall. But the simple proposition was that despite the judge's desire that it should be so, validity accepted would, and he used the word foundational, that it would actually move matters on, but it wouldn't be possibly in some respects definitional, he said, I think, another expression he used, but it wouldn't be dispositive. But that's a little highway and byway. If I've amused you in doing so, then that's a good way to move up to the short break. But the relevant point here is that I have no doubt of any kind whatsoever that the creation of the revenue rule trial was intended to be dispositive of the revenue rule issues. And what I'm going to, I hope, persuade your lordships in a few moments, is that if the approach being taken by Lord Panic and the SCAP team now is correct, it won't be, or it might not be. And we could be left in a situation where you're simply being asked to read the pleading, bring down the portcullis on one point, it's fraudulent, therefore revenue rule doesn't apply. But Lord, we could end up in a situation, perfectly possibly, where we have mixed findings on numbers 1, 2, and 3.
I mean, that's a sort of. If I follow where that's going, Mr. Jones, I mean, that's effectively saying this was a bad idea in the first place.
Lord, no. With respect, I think what I'm proposing is that it was never set up as the limited exercise that it was portrayed yesterday as being. That is to say, that akin to a CPR Part 3 application, everyone, including the court, was bound to accept as correct the pleaded case. Because we say, in order for the court to take a view about the characterisation exercise, you need to look at the substance of the claim.
Well, that's the point
Yes.
Sorry, I'm probably not expressing myself very clearly.
Lord, and I interrupted you, I'm so sorry.
No, you didn't. Anyway, we're in court now. We're not on screen, so it's much easier to interrupt the court. And much easier for the court to express displeasure of being interrupted. The point I had in mind is this right? Or my misunderstanding that one could envisage. Let's assume that there hadn't been a preliminary issue trial, and the whole case had gone forward to trial. So all the validity issues were determined at a full trial. But you could have ended up with a result along the lines of what Lord Panic is suggesting, that the revenue rule did not exclude these claims.
You could.
Or you could actually end up with a result that it did exclude the claims. But that would only be determined at the end of the day.
Well, so the question is, did we go into this not entirely cheap exercise of a revenue rule trial on the basis that it was going to be hidebound? I'm sorry, I don't mean that to sound pejorative, but hidebound by the pleadings. And I respectfully submit that we didn't, and I don't believe we did. There was a right royal argument between us and SCAT at the PTR for the revenue rule trial, because they invited us to go first on the basis that we were effectively trying to strike them out. We said it's a trial, you go first, and the judge agreed with us for what it's worth. And there was also then a question, and you've heard references to it in the papers already, about whether there was or was not the exercise of public powers, and how was the judge going to deal with that, because it didn't appear in their particulars of claim that they did. And we were taking the point that it can't possibly have been the position that we were going into the revenue rule trial on the basis that it was hoped that it would be dispositive either way, on the footing that the whole case would be, that characterisation exercise would in fact be determined by SCAT's pleading. Let me just take a very simple example. Paragraph 1 of this pleading says they bring this claim in a private capacity. Well, that's actually part of the characterisation exercise. I don't wish this to sound flippant, but if the court at the preliminary rule trial was in fact bound by the pleading, on one view, we might not have got further than paragraph 1.
This is a slightly expensive exercise of unreality, isn't it? I mean, if in any such trial, you may have sentences in the pleadings which are not determinative, of which you've given an example. So, right up to the point of alleging existence of a duty of care, which may be alleged by the claimant, but you've still got to resolve it. So there wasn't any lack of clarity about the exercise that was being done by the judge, was it? He was taking the substance of the allegations being made by SCAT and ruling on whether they fell foul of Dicey Rule 3 and the Brussels regulation.
But by looking at the substance of the claim, he wasn't hidebound, for example, by looking only at the way it was pleaded, because he would also have had in mind what was pleaded in the defences. He would have in mind the issues, and we had long submissions about that in relation to questions of comity and so on, which I'm not dealing with, as to whether it was a relevant factor in the revenue rule trial decision that there would in due course be a deep dive trial looking at the way in which SCAT administered its own revenue system in its own country, which would form part of the validity trial. So,
Speaking entirely for myself, I don't understand how these submissions assist us in defining and deciding the issues that arise on this appeal. But I may be missing something, which a short break may make clear.
well, Lord, I've got a note here saying I should offer you a break at 11:50, which is where it is in the timetable, but it's entirely up to you whether you want to take it now or in
No, we'll
5 minutes
have
time.
a 5-minute break now.
Right, thank you.
Court rise.
We want to share this. Nothing I'm saying. It's up to you. Yeah, absolutely.
That one there.
No, that one is
So that was connected to this machine in the same way that the person is using this up here. Sure. I'll need to ask someone to bring this actually in, otherwise it just boxes. Unfortunately, that's not my aim, but I can put that in there. So swap that one over to the APA group.
Yeah, looks good here.
I'm not interested. No. Oh, thanks.
She stayed independent.
Yeah. I don't
We are doing our I might just dump that.
Is everyone ready? Is everyone back? Okay.
Yeah, I think so. Let's press on. I'll have to come in and be embarrassed if they're not here.
Everyone ready? Yeah.
I fear I wasn't moving through that particular point as swiftly as I could do, so I'm not going to labour it more, but I'll just make two or three very final points on it, please. One, for example, if Scat said in its pleading this was not a tax case or didn't have anything about tax, that would not be determinative of the characterisation point. So I think I'm pushing at an open door there, but I'm just trying to draw the distinction but by saying that as alleged should not bear more weight than it was designed to. We've then got the point which is clear from paragraph 101 of Justice Andrew Baker's judgment, which you'll have at CB1/3/30, where you'll remember this is the paragraph 101. This was the paragraph in which he said, well, I understand Scat says X, but that actually begs the question it seeks to answer. So that we respectfully submit was an entirely appropriate conclusion for the judge to draw as part of his judgment, which was essentially a characterisation judgment.
Yeah.
So simply, therefore, the case isn't going to be, should never have been determined, and wasn't indeed by the judge determined, based only on the pleading as alleged. He took into account, we very respectfully say properly, as it were, if I use the expression, the space between the parties, in other words, what the claim was all about in reality. And what, as alleged, was designed to deal with, we respectfully submit, was that he would not be resolving disputed issues of fact. but he was entitled to stand back and did stand back and look at the substance of the dispute and decide whether it was caught by Dicey Rule 3. And if your Lordship's making a cross-reference, when you come back to this point, I'm assuming, I hope not impertinently, that your Lordships are not intending to deliver a swift judgment on Thursday afternoon. When you do come back to this, you might also, as a margin note to 101, also put judgment paragraph 119, which will I think reinforce what I've just been saying.
Jones, preliminary issues are, although they are preliminary, they are issues defined on the pleading. So there's no doubt that the judge deciding a preliminary issue isn't bound by anyone's pleading. He's deciding points as per the pleading. So I'm really not sure where any of this takes us.
Well, I think I admitted when you came back in, I'd probably spent longer on this point than it deserves, and I don't seek to say more about it. I then want to move on to another heading, which is what I've called the inconsistency at the heart of Scatt's oral submissions. With respect, I say that is as follows. The central point that Lord Panic tried to take away from more or less every case he referred to yesterday morning was that there has to be, for Dicey Rule 3 to be engaged, an unsatisfied claim for tax. Now, as you know, there is an issue in this case about what that means. That's a different point, come back to that. But that is Lord Panic's test for characterisation. He then accepts that if there is such a claim for tax, then any claim brought in England which seeks directly or indirectly to recover the value of it is caught by the revenue rule, because he conceded fairly and squarely, rightly with respect, but he fairly and squarely conceded it, that if you're caught by the revenue rule, the fact that you've been engaged, or the defendant has been engaged in some fraudulent activity is absolutely irrelevant, because the rule is the rule. So the rule doesn't apply other than when you've been fraudulent, and does not apply when you have been. If that is correct, then the starting point for this is that the allegation of fraud is not relevant. I do accept that what is relevant are the cases he took you to searching for the unsatisfied claim for tax, and the respondents have an absolute answer to that, we have an answer, and we would say it's an absolute one.
I'm sorry to be picky, but this is an important submission for your case. That you said if there is a claim for tax, he accepts that if there is such a claim for tax, then any claim brought in England which seeks directly or indirectly to recover the value of it.
Yes, well, because if
so not the claim for tax itself, but something that is equal in value to it. Is that your submission?
Well, it would have to be, because if we look at Buchanan, for example, the claim that was sought to be brought in Ireland was not a claim for the tax. The claim was a claim by the liquidator for
it's indirect enforcement. It's held to be indirect enforcement.
Yes, well, I use the word value, in other words, to capture the question of indirect.
Okay, thank you.
So if that's correct, fraud ought to be irrelevant. Now, when they say fraud remains relevant, it becomes rather circular. Because if fraud is relevant to the question of characterisation, then it could prevent a claim being caught by the rule in the first place, which, in my submission, negates the concession that fraud is irrelevant once the claim is caught by the rule. So I'm only going to leave that thought with you and invite you, when you've heard all the submissions from all the respondent teams, to bear in mind the proposition that there is a potential inconsistency in the basis upon which the submissions proceeded yesterday morning on ground one, on that central issue. That the question of characterisation, once it is admitted that fraud would not take it out of the revenue rule once it was in it, or would otherwise be caught by it, then it's difficult to see on a stand-back analysis why fraud should be a factor in the characterisation process to start with, because those two concepts will not work one with the other. Now, if that is right, then
I just don't see that at all, because what the distinction Lord Panic is drawing really is between fraud on the part of the taxpayer and an attempt to get back unpaid tax from the taxpayer directly or indirectly by enforcement proceedings of one kind or another in this jurisdiction would be caught by the revenue rule, despite the fraud of the taxpayer. And this fraud, which he says is, as the American judge says, whatever his expression was, common or garden fraud, by somebody who wasn't the taxpayer, who's just a fraudster, who's just using the Danish tax system to, as it were, to game the system in order to commit a fraud.
I understand how Lord Panic put it yesterday, but you will also understand that between the respondents we have significant submissions, which you've seen in writing and you will hear developed during the course of the day, that this is in fact a tax case where there is a relationship between the tax authority and the claimant. But the whole the question
only by virtue of the making of the fraudulent application.
Lord, that if I would say so, going back to Mr. Justice Andrew Baker's paragraphs 101 and 119, begs the question that the characterisation question seeks to answer.
But do you submit that anything other than or prior to the making of the allegedly fraudulent application gives rise to any relationship between the applicant and SCAT?
Well, the position is that when we look at we're not going to look at the trades in this trial, but it's a relevant question that there were trading structures which the defendants say would lead the applicants to have the ability to make those reclaims. And the Lord Panic's submission yesterday, it doesn't get them where they want it to get them in circumstances where, as I've demonstrated to you, the first three of the allegedly false representations are all about tax. The dishonesty representation is in little d, number 4. So it's more complex. It depends, if I may say so, I've said this twice already, but in a sense, it's where we start the clock. So we have to look at everything that is in issue, everything that the claim concerns, in order to decide, I would expect to submit, what is the true characterisation of the claim. So
what's said I mean, whether one's looking at the pleading may not matter. The first representation is that the applicant was the beneficial owner of the shares. That is said to be a fraudulent misrepresentation because the applicant didn't own the shares beneficially or at all. Then the next one is that they beneficially received the dividend net of tax, and it said that's fraudulent because they'd not received relevant dividends from the companies beneficially or at all. And then it said that the dividend being paid to the applicant after the Danish company would withhold the tax. It said that's fraudulent because they've never received the relevant dividends from the Danish companies beneficially or at all. Now, those are three allegedly fraudulent misrepresentations about the underlying facts which led to the tax authority paying out the money.
Led to the
tax to do with tax at all.
Led to the tax authority paying out the money, having established a system whereby they would themselves establish and reserve to themselves the right to establish the right of the applicant to the refund.
Is it possible to defraud the revenue without engaging Dicey Rule 3?
The answer to that is a question. The question is a wider one than I'm fit to answer. What I would prefer to answer is to say this, rather than a global answer, is to say on the facts of this case, the judge was entirely correct to say, on a stand-back analysis, that the substance of this claim did engage Dicey Rule 3. Now, there may well be cases where you could defraud a revenue without it engaging Dicey Rule 3. And there will be clear cases, a canon, for example, where the court has found that Dicey Rule 3 was engaged and everyone appears to accept that. So, Lord, my answer to your question is that I don't want to take on the burden of saying in what circumstances you might or might not defraud a revenue, But in these circumstances, this particular claim is one which falls within Dicey Rule 3 for the reasons the learned judge identified. And I've already taken...
For example, banks are parties to complicated clearing systems which are engaged by people signing checks and presenting them for payment, etc. But one wouldn't say that if somebody forges a check and presents it for payment, one wouldn't say, well, they've engaged the banking system and the bank is thereby honouring the check. No, it's a straightforward fraudulent misrepresentation which causes the bank to give them money. And it's to characterise it as in the context of the system which they are abusing, completely turns the thing on its head, doesn't it?
Lord, with respect, I would submit that the banking analogy, like all analogies, isn't going to be perfect. We should look at this particular set of facts. We have to look at the allegations of the trades and the defences to those trades. In other words, the issues which will arise in the claim as to whether those trades are capable of being valid and lawful, for want of a better word. Now,
But that's a different question with respect. I mean, that's the issue that would have been decided on the validity trial.
Indeed.
If the judge had decided ground one the other way and decided the revenue rule wasn't engaged. But the basis on which we're invited to conclude that he was wrong is that there was fraud. So there's no point praying in aid that the trades may have been valid. I mean, it may very well be, if this appeal succeeds, there will then be a validity trial. And it may be that at the validity trial you establish that there wasn't fraud and these were all genuine transactions.
well, the question, I understand your Lordship's point entirely. The question then becomes how narrow a question you ask in order to decide the characterisation of the substance of the claim, which comes back to points I've already made.
We're asked to decide, and Lord Panic has made it absolutely clear. He's not saying it is determined for all time that there was fraud. He's saying you, the Court of Appeal, should proceed on the basis that there was fraud as described in the pleadings. On that basis, is the revenue rule engaged? And he says no. Now, if we were to decide in his favour, it would still be open to you to say to the trial judge at an eventual trial that this wasn't fraud and therefore the revenue rule was engaged because these were genuine trades.
Indeed. Well, I could say whether that's going to be conceded a la EDF man at that stage by Scat, who knows, given the lack of formal concession today. But my concern is to stand foursquare behind Mr. Justice Andrew Baker's judgment precisely because he wanted this to be dispositive. I understand we all wanted it to be dispositive. And in order for it to be dispositive, the court needs to be persuaded that the analysis that he undertook, which is a wider analysis than the one Lord Panic invited your lordships to take yesterday, was the correct approach, because there we are identifying the true substance of the claim and identifying that it is in fact a tax claim, and that it doesn't not become not a tax claim simply because Lord Panic's current submission is to say what you do is look at one moment in time, you allege that that application is fraudulent, and you ignore everything else because this is all about tax, and it's all about how the Danish revenue system sets up creates and implements a system for withholding tax and for its assessment of withholding tax reclaim applications. And there's no going around that. And in our submission, what you can't do is just to extract one slice out of that and say, we'll put all that to one side.
Why is one doing that? One looks at the whole time of the process and says, was there at any time here a claim for tax against this applicant? Not at one point in time, at any time.
Well,
Was this applicant ever a taxpayer in the sense that the system, however complicated it was, adopted by SCAT, was the applicant a taxpayer? Did the applicant ever receive any dividends?
But your lordship is, I'm sorry if I interrupted, my lord Chancellor.
No, but I'm just saying, I think we're seeking to suggest to you that that's all part of the background to the fraud on the SCAT case.
Lord, if the relevant question to Lord Justice Phillips is challenged to me, if the relevant question is phrased in the way you phrased it, which is, shouldn't we be looking whether there was at any stage an unsatisfied claim for tax? Well, I respectfully agree with that proposition, because I don't shrink from saying that when Lord Panic took you to cases yesterday to say that that's a relevant question for characterisation, I agree. Question is, was there? And the time at which you asked that question is the entire period of time up to the time when the claim commences.
You said a moment ago, or you characterised Lord Panic's submission as being what you do is look at one moment at a time, you allege that the application is fraudulent and you ignore everything else. Speaking entirely for myself, I'm not convinced that that's a fair characterisation of the submissions we heard yesterday.
Well, I may have put that too brusquely, but my point is that you have to stand back and look at everything. Now Mr. Justice Andrew Baker did that. He had, well, you can see from his judgment, I need to go through it, but he took into account in the question of characterisation a great many factors. And in my respectful judgment, he was right to do that, because otherwise what you actually end up with is a situation in which a Foreign Revenue Service could predetermine until trial the outcome of a revenue rule challenge simply by how it creates its own system in its own country and how it pleads its case. Now, that can't be right. It can't be right, because this court should be looking at the substance. So let's supposing, for example, we take the situation between us and EDNF Man. The claim against Solo could even have easily, the Solo applicants could easily have been put on the same basis as the claim against EDNF Man, put in negligence. But they've chosen to put it in fraud. So what they would then be doing by that, could well be argued that if it was a fraudulent representation, it was also a negligent one. What they're therefore doing is holding this court to ransom and saying, well, we've only pleaded fraud, therefore you have to let this case go forward. But that with respect, that then shows why that is an unsatisfactory way, I would respectfully say, of approaching the question. Because if this case is inadmissible in an English court, the sooner that is analysed, characterised, and that decision made, the better. It cannot, with respect, be I was going to say sensible, but that's going to sound impertinent. It can't be the optimal way of running the revenue rule that, in effect, you allow the pleader to determine whether it survives at the early stage, and you wait until the end to decide that actually you can't deliver judgment in favour of the defendants because the entire claim was inadmissible in the first place. If that decision can be found and decided now, and we respectfully submit that it can be.
Assume Lord Panic is right, that this was a fraud of the kind that he describes. The court is just deciding on this appeal whether the judge was right to shut the case out on the basis of Lord Panic is right as to what the factual situation is. Now, as I said to you a moment ago, it may be that at an eventual trial will establish something different, in which case the result will be different.
Well, I come back to where I started, the efficacy of the...
I mean, for example, presumably your clients deny that there was a fraud, and you may accept there were some misrepresentations, but they were only negligent. Well, then the court will have to decide that and decide whether or not the revenue rule applies in those circumstances. All that Lord Panic is submitting, as I understood it, is that if this is the fraud that he says it is, it falls outside the revenue rule.
And our submission to this court is that Mr. Justice Andrew Baker got his analysis right because he took into account that which he should have taken into account and properly characterised what he found. Therein lies the the essence of the appeal. That's obviously emerged yesterday as being the key point. There are lots of other points, but that's obviously a big one. I've made the analogy with EGF man. You could run that analogy the other way round. It doesn't really much matter which it is. So, but picking up Lord Justice Phillips's point to me, if the real question is whether there is an unsatisfied claim in respect of tax, then that can be answered by this court because you're looking at the claim that was issued in 2018. And at that point, if at no other, there was an unsatisfied claim. And indeed, there would not be an unsatisfied claim until such time as SCAT had revoked or purported to revoke its earlier decision, and we know that was in 2017 and 2018. But perhaps it might be useful just to give you the references to those documents now. So let me take you to those straight away. It's taken me a little bit out of the order that I had, but I don't actually think that's going to be an issue. So I'm pretty sure we're going to find it in SB1. And if I don't know if you've looked at these before. If you have, I need to correct something. So it's SB1/2. Page 1.
It's been updated overnight.
Yeah.
I'm looking at a document which says certified translation.
Lord, may I just ask whether, because there were hyperlinks, whether any of your lordships have actually looked at this one and the 2018 document before today?
I've looked at this
You've looked at this
before today.
Lord, have you looked at the certified one or the previous one? Because it was only uploaded overnight in this version.
The previous one, because I don't remember seeing certified translation.
Right. So let me explain the difference. Which the old one is no longer there. It's been swapped out. So originally we were given a translation by SCAT, and I don't wish that to sound in the least bit critical because all translations are automatic in the first instance, and that is what went into the trial bundle, and that's what our skeleton argument referred to. After Christmas, they produced certified copies of it and showed that there were some infelicities in that original translation. So there are one or two points in our skeleton which as a result of the proper translation, we will no longer pursue, and I'm not going to trouble you with it now, but I will send you the court a note to say which bits to cross out. So the point here is if your lordships just look very quickly at pages 1 and 2,
Well, either we looked at this yesterday or I looked at it separately because I've highlighted the second paragraph on page 3, which is page 2 of the letter. SCAT therefore reclaims.
yes. Well, I'm grateful that your lordship has looked at that already. So if we look at page, the first page, page 1 of 12, there's a couple of points there. We'll pick up at the bottom of the first page, the expression heads area does not meet the conditions. SCAT therefore refunded. SCAT therefore reclaims the previously refunded dividend tax. And there's reference immediately thereafter to the 3-year limitation period for any such claim. If we could then go, please, to SB1/3/1. This is in a slightly different form, and I think Mr. Beale may be taking you back to this in due course, but there are a number of passages which demonstrate that there was a revocation of that original decision.
Forgive me, Mr. Chancellor, on the assumption that SCAT discovers that it's been defrauded in the way that it thinks that it has, how do you say it should go about getting its money back?
Well, Lord, Mr. Beale will address you on cross-border tax and cooperation. It could do that. If it can't do that, then that should have absolutely nothing whatsoever to do with the characterisation of the revenue rule. May I explain that? I had this note in my note a little bit later, but may I take it now? If the common law exists, and it does, and it's a rule of inadmissibility, then if you'll forgive the expression, it is what it is. Now, if we're right, and the trial judge was right to characterise it in the way he did, then the answer, the question your lordship puts to me is, if I may say so, not an appropriate question. No, I don't mean that at all disrespectfully.
Because the answer may be it doesn't.
Well, the answer may well be it doesn't, because the rule is the rule. And Lord Panic anticipated that you might hear from our lips, in aggregate, safety lies in universal rejection. But it's absolutely what the rule is. Now, MARD, as I understand it, and I'm not a tax expert, but MARD, as I understand it, operates at an intergovernmental level so that governments can choose to create solutions to each country's version of the revenue rule. That's what it's designed to do. So if you find, or one finds, a missing link in the intergovernmental system, it's not appropriate to come back to the common law and recharacterise what you would otherwise have characterised it a certain way in order to make up a shortcoming in the intergovernmental solution. The shortcoming is not in the rule, it's in the intergovernmental solution. So if you'll forgive the colloquialism, this is it could be seen as a tail wagging the dog question. But here, we should not be deciding this case, if I may respectfully say so, on the basis of whether there is or is not an alternative remedy. That is not the correct question. It's a jury question. It's a forensic jury point. It's a point made by
I think your answer to my question, although you're deferring down the line to some extent, is it doesn't unless there's an intergovernmental response.
On the facts of this case. There might be other frauds which are entirely appropriate, which have got nothing to do with collection of tax. So for example, you could be a cleaning company providing services to an office of the Danish revenue in this country, or providing aviation services to the Danish revenue in Denmark, but based in this country. And you might, in that regard, commit a fraud. You might overcharge them for tickets. So I'm not being flippant, but your lordship's question, in a sense, is very helpful, but it doesn't actually grapple, if I were to actually say so, with the point that we've got to grapple with. What we've got to grapple with is the question whether on the stand-back analysis of the substance of this claim, it falls within the revenue rule. And if it does, it's brutal. It's a preclusionary rule. I accept it's brutal, but in fact it's brutal because it protects citizens of this country as the Danish version will protect the citizens of Denmark and Germany and so on and so forth from that which is considered inappropriate interference in the affairs in this country. Now, there will be circumstances that a preclusionary rule will operate unfairly or seemingly unfairly, depending on what your view of it is. But it doesn't matter. So if we're right on characterisation, we shouldn't be then unseated from that characterisation, because on the facts of this case, there may be perceived to be a hole somewhere in recovery. And Mr. Philip Baker certainly didn't accept that there was a hole in mild recovery. He said very firmly that there wasn't. And that's not been determined by Mr. Justice Andrew Baker at this stage, but there it is. Well, I don't have to determine that point, and your lordships don't have to determine it, but it's an appropriate submission from us to make, to say that if you conclude that there may not be a marked solution, or if you accept from Denmark's pleading or its submissions that it has no alternative solution, the brutal answer is, do we fall within the preclusionary rule or not? And if we do, then I'm afraid that is the conclusion which comes from safety lies in universal rejection. So your lordship should not be, as it were, I very much hope I can persuade you not to allow yourselves to be influenced in any way, shape or form in the characterisation question by what you think the consequences of that are, because that is an intergovernmental issue, not a common law issue, I respect to submit. Look, I am going to, I think, now give way to Ms MacDonald. I'm well within my 90 minutes, but I want to leave a little bit of space for Mr Beale to expand his section, because he was nominally only in for about 30 minutes. I think that the tax issues deserve more of an airing.
You showed us these revocation documents, but you didn't say anything about them.
Well, look, I've only taken you to those documents because in where I was, Mr Beale's going to come back to those. He's going to actually take you to about 7 or 8 pages from them and quote. I didn't want
But your
to
point
repeat
is
it.
they talk about reclaiming tax.
Yeah. So I was dealing with it at a generic level. Mr Beale will look at it at a detailed level. But Lord, I'm sorry if you felt that I left that hanging and not made that clear. That was the scheme, and I should have explained it when I embarked on it, that that's what I had in mind. Lord, unless you think I can help you further, I'm happy to give way, and I'll make the rest of my comments between the respondent groups privately. Thank you very much.
Yes.
My lords, my submissions in the hour and a bit which I have on the batting order will be in 2 parts. Firstly, I will address why we say that the judge was right to find that when characterising a claim brought by a state for the purposes of Rule 3, A, the substance of the claim is determined by the central interest in bringing the claim of the sovereign by whom it's brought. And for the record, the judge so found at paragraph 75, Rule 4.
Now, we've got problems here because certainly the acoustic is odd in this court. Sometimes if you're way over there, it's difficult to hear, and I think you're not being picked up by
Would
either.
the transcribers like me to pause and they come round and adjust the microphones to the place
Well,
where
I'm
they
just
would
wondering
pick me up?
whether it might be sensible if you swapped round and went where Mr Jones was, if that's not going to cause you all sorts of problems, because maybe that's what the problem is.
Otherwise, I'm entirely content to shift. It may mean that the court might like to step outside for a moment, or they'll have the undignified spectacle of my bringing my voxies with me.
I mean, I think
Or I can just,
it's not just me.
I can
But I mean,
simply
this is my court, so I know
shout out.
of old that particular spot where you are is sometimes an awkward one to speak
My lords,
from.
if I'm in the dead zone, I'm perfectly happy to move. I'm not quite at full lung capacity after a recent COVID bout as well, so there may be a slight element of quietness
Well,
in my
rather
voice
than you
that
being
doesn't.
uncomfortable trying to sort of shout at us, Ms MacDonald, I think perhaps we will rise for 5 minutes. Once you... Yes.
I think you wanted to, I got the impression that you wanted to ask something.
Yes, my lord. I was just confirming we can hear our speaker on the call. If you cannot hear the speaker in the call, perhaps I could add some amplification via the speaker to your left. Otherwise,
No, well, we can't hear you either. So. No, we'll rise for 5 minutes.
I think the suggestion is they may be able to amplify the sound into that speaker and angle it towards you. I think
One way or
that's the
another,
suggestion.
we'll rise for 5 minutes so that somebody can try and
Understood.
Court rise.
Well, I don't want you in a position where you're having to shout.
I'm grateful. Yes, so you and I should switch. And I will just slide my stuff over, slide that thing there. Nigel still is.
Yeah, about Tom. Does Tom need to come with me? Why doesn't Nigel switch out for Tom? Can Tom come to your left?
Yes, yes, perfect.
Nigel will be where
move on.
Do you mind being?
No, not at all.
It's just easier for Alison to have a junior next to her.
Remove this, I've got a speaker, so you don't have to move.
Okay.
Oh, if
That might be easier
the
for
court,
you.
will that mean the judges can hear you properly?
That's the goal. But I'll-
Okay.
Okay.
We're trying to sort it out now.
Can we do a test run with you listening?
Can we test that? Could you sit? Would someone mind sitting and hearing what they'll hear if we do that? Because I don't want us to take the break doing that and that doesn't.
Basically, what we'd like to do is for judges, this up here. And there are cables between the two. So these will be basically sound reinforcement from
It's too complicated.
It's a lot of audio, you know? History, which is why I didn't like it in the first place. So we resolved that issue, but they couldn't run the bench. That's what, and almost exactly as said, I couldn't hear them. No, so game of cannot hear communication. Check apps on, yeah?
Sorry.
Sorry, I was with my colleague. So what we'll do is, so this microphone will pick you up for the purposes of the call. This microphone I might move back here just in case anyone needs to interject from this side. And what we're going to do is, you can hear me now. I'm actually going to feed a little bit of these microphones directly back to the judges. So that they can
Do
hear
you
you.
mind if I speak? Would you mind sitting up there for a moment just to see
Of course,
if
of
you can
course,
hear?
of course. That's exactly what I intend on doing with my
Brilliant.
colleague at the back there. So
Thank
I'll make
you.
a couple of quick adjustments before we come back in. So maybe trim the mix a little. Do you mind just speaking for me, please? Do you mind speaking a little bit for me, please?
Okay. So how does this sound up there?
I can hear you loud and clear here.
Yeah.
And again?
And in the middle? How's that?
Yep, I can still hear you. And
And on the end?
on the end?
How's that sounding? Is that
What was
doing
that?
okay?
Yeah, I can hear.
Great.
It's not going to be, public address loud.
Well, that's, yeah, we probably don't want
It's
that.
more just so it's a little bit of reinforcement.
Boost. Thank you.
Office team, is that okay? Should I call them in?
Yes.
Is everybody ready? What rise?
Your Lordships will see that I'm in the same place, but I hope that I sound almost eerily, slightly amplified from the speakers that have been placed there. The Opus team were keen to have that as the solution, and that also, of course, ensures that anybody who ends up sitting in this seat for the remainder of this hearing will be, I hope, audible to all.
Yep.
And my lords, I was just setting out what I hope to cover in my hour and a bit. Firstly, and these focus on some propositions of law and then their application to the facts by the judge. So firstly, why we say the judge was right to find that when characterising a claim brought by a state for the purposes of Rule 3, firstly, the substance of the claim is determined by the central interest in bringing the claim of the sovereign by whom it is brought. And for the record, the judge so found at paragraph 75, Roman 4 of the judgment, CB1/3/24, although we did not bring it up on the screen just now. And I will submit this is the test in all cases, tax or otherwise, because as the judge correctly interpreted the case law, penal, revenue, and other public laws are simply, as this court put it in Basogo, good examples of acts done by a sovereign by virtue of his sovereign authority. And we'll look at that passage shortly. So secondly, my submission will be that the mechanism by which the alleged harm is said to have been suffered is a necessary and an important part of judging whether the central interest in bringing the claim is indeed a sovereign one. And then as the second part of my submissions, I will look at why, when it came to applying those legal principles to the facts, the judge was correct to reject Skat's attempts to portray its case as a simple patrimonial claim. My lords, my main submission is that the appellant seeks to avoid the application of the rule by describing its claims in an overly abstract way. The learned judge, we say, looked at the underlying reality of the situation and correctly concluded that Skat's claims are sovereign in nature. And this is because, as I will develop, however one characterises the alleged wrongdoing, the mechanism by which the alleged losses were caused is Skat's sovereign decisions to grant and to pay the tax refund applications. And this also, we say, provides the dividing line between this case and other situations which were discussed yesterday, including, and I will address this in due course, the person who tunnels into Skat's safe. So we say that there is a sound and principled reason to draw a distinction between that type of claim, which ought clearly to be allowed to proceed, and the claim that we have in this case. So my submissions are essentially exploring, firstly, the case law basis for drawing that, and then, as we say, the judge's correct appreciation and application of those principles.
What about the bribery of a Scat employee to make tax refunds to the defendants which aren't due?
Well, that is an example which I'm going to address specifically, and if I may, what I'll do is I will lay the foundation, I'll lay what we say is the legal foundation for the answer which I will give in due course to your lordship's example. This is obviously a case where partly perhaps because of the complex nature of the trading structures, and also particularly in appellate courts' desire to look at matters as a question of principle and general legal application as well. This is naturally a case where examples, concrete alternatives are replete, and we accept that our analysis has to be capable of drawing a line in a correct place. And so what I seek to do is to build up step by step the legal foundations for the line which we say the judge correctly drew. And as part of that process, I hope to address the various examples which arose yesterday. So my first task here is to tackle the appellant's argument that when the learned judge was identifying the legal criteria for an impermissible sovereign claim, he should have confined himself to the pure tax case law, and in particular to Taylor. This is part of the theme that was developed yesterday of the narrowness of what the appellant puts as the revenue part of the rule. And one sees this point perhaps expressed most clearly in the appellant's supplementary skeleton argument, which, if we can have it on the screen, is at CB4, tab 29, and I would direct attention to electronic page 2 of that. And I'm looking in particular at paragraph 3.1 to 3.3. And at 3.1, your lordships see this criticism precisely expressed. The complaint, and your lordships can read the paragraph, is that essentially, in concluding that this was an indirect attempt to enforce foreign revenue laws, the judge drew upon principles which had been set out in cases including, in particular, the decision of this court in Sogo. And then one sees the strong language at the end of this paragraph, the final sentence, where the appellant says this led the judge into error because in concluding that Scott's claim infringed the rule in Government of India and Taylor, he expanded the well-established boundaries of such rule by reliance on extraneous considerations, strong terms there, of course, relating to the wider genus. And that's an important submission by the appellant because it founds their approach that there are two distinct categories here which ought not to meet. And in particular, as I'll show the court, the judge, in reaching the decision that he did, drew heavily on Sogo. And in my submission, which I developed now, correctly so. So we say this wasn't an error in the judge's analysis. And on the contrary, when we follow through this particular strand of the judge's reason, it helps to shed some important light on why the appellant's reliance on the concept of fraud does not take its case outside the scope of Rule 3. To start with on this point, I would go firstly to the judgment of Lord Denning in the Court of Appeal in Attorney General of New Zealand and Ortiz. This is at Supplementary Respondents Authorities 1, tab 14.
Volume 1, tab 14.
Volume 1, Supplementary Respondents Authorities, Volume 1, tab 14. Just waiting for that to come up on the screen. And this was the case, as the court will recall, where New Zealand sought to regain the beautiful carved doors, which if we go to electronic page 13, we see described at the start of the speech of Lord Denning, judgment of Lord Denning, the door of the treasure house. So we see there what they were dealing with, which was an important item of cultural property. And the court will recall, and this was looked at yesterday briefly, that New Zealand was unable to recover this cultural property on the basis that its legislation prohibiting the export of works of cultural heritage and forfeiting them to the state if they were to be exported or there was an attempted export counts as a public law which will not be enforced in England. And we see Lord Denning's decision to that effect if we jump forward to page 24. And we look at D to E. And the first paragraph under conclusion, we see Lord Denning setting out what he considered to be the answer. And this was, of course, different to the Iranian law in Barakat, which vested ownership of artefacts in the state from the moment of their discovery. And this was an important point of distinction which we will come back to very briefly towards the end of my submission when I look at the public policy exception for which the appellant contends. In any event, going to what I would submit as relevant for our present purposes, if we move ahead to page 20, move back to page 20 of the electronic bundle, there is a section entitled Recognition and Enforcement. And there Lord Denning considers at 20H, what is the general concept which embraces penal and revenue laws and others like them? And he gives the answer. It is to be found, I think, by going back to the classification of acts taken in international law. One class comprises those acts which are done by a sovereign jure imperii, the other which are done by him jure gestionis. And then, and your lordship saw that passage previously, and of course I fully accept that begs a very important question which is part of this appeal, so this is merely the starting point of my analysis of how we get to the answer in this particular case. But at page 21, if we go over the page, if we look at paragraph E, if we go down a little, yes, thank you. Lord Denning is asking the question, the very question with which your lordships are grappling now, well, how do we draw that line? And he says, I suggest the first thing in such a case as the present is to determine which is the relevant act, then to decide whether it is of a sovereign character or a non-sovereign character, finally to ask whether it was exercised within the territory of the sovereign state, which is legitimate, or beyond it, which is illegitimate. Now, the need to identify the relevant act. I'm sorry, did your lordship have a question?
No.
One is alert, and it's a pleasure to be in court in person because one can be more alert to what one thinks might be a judge bending forward with potentially a question, perhaps overly alert.
No, I was just thinking about Lord Denning.
So the need to identify the relevant act, as Lord Denning says, is an important point which I'll address shortly. And I'll make the submission that the appellant does not, in fact, do this. So for present purposes, the reason I draw the court's attention to Lord Denning's analysis is because we see that there is no distinction there for him, or no suggestion that the relevant principles or the characterization exercise differ according to whether the case involves penal, revenue, or other public laws. On the contrary, Lord Denning sees those categories as simply examples of the general concept of sovereignty. And Lord Denning's approach was adopted by this court in Untitled. Now this is a decision which your lordships have seen yesterday, and there are a few passages of this to which I will direct the court's attention in due course through my submissions this morning, because in my submission it's of considerable assistance, and that does not cease to be the case because the case has what Scap describes as a background in the tax system. Now, Umbasogo is at PA 3, Principal Authorities 3, tab 22. And as your lordship saw yesterday, in the course of a comprehensive review of the rationale and the scope of the rule, prepared, as we see from the judgment, primarily by Lord Justice Dyson, as he then was, that section of the judgment, the court referred at paragraph 41, if we can jump forward, paragraph 41, to the analysis of Lord Keith in Taylor and Lord Denning in Ortiz. And we have paragraph 41 is at electronic page 25. And lordships saw this passage in the course of the appellant's submissions yesterday, but it take the liberty of coming back to it because it is of some significance to the submissions that I am developing. And we draw attention to the observations by the court that the courts will not enforce or otherwise lend their aid to the assertion of sovereign authority by one state in the territory of another. So far, so good. And the court goes on to say, claims to enforce penal or revenue laws are good examples of acts done by a sovereign by virtue of his sovereign authority. In each case, it is necessary to see whether the relevant act is of a sovereign character. Penal and revenue laws are assumed to be of a sovereign character. And the court then reiterates this conclusion, page 28, electronically, paragraph 51, where it observes that it is true that most of the cases concern actions for the enforcement of penal or revenue laws, but as we have pointed out, these are merely examples of a wider principle. And I would ask you, Lordships, to bear in mind the phrase examples of a wider principle throughout my submission, because that's really the nub of the point that I'm making as the first stage of my analysis. And to be clear, and as the court will appreciate, the position of the respondents is that this case is a tax case in the narrowest possible sense that SCAT could draw it. And this is a point which will be developed by Mr. Beale in due course. But the point that I am making here is that cases such as Ortiz, such as Mbusugu, make clear that the issue for the judge really was whether SCAT's claim is a sovereign rather than a patrimonial one, of which tax claims are merely an example. And so in reaching the conclusion that he did, it is not right for the appellant to say that the judge took into account erroneous or irrelevant considerations, extraneous considerations is the language you saw, by taking into account the guidance that I've just shown the court from Ortiz and Mbusugu. That guidance was expressed as being of general application, and he rightly treated it as such. I'm going to build on that in a moment, but before I do so, I would address very briefly the appellant's argument that Taylor and Williams and Humbert, taken together, require there to be an unsatisfied tax claim in the foreign state. Now, the submission of the respondents, as you've heard, is that the judge was on the facts correct to find that if there is such a requirement, it was met in the present case. And again, this will be developed in Mr. Beale's tax submissions when I have concluded. Now, the point that I would make separately to that is that when one thinks about it, it is difficult to apply the analysis in Williams and Humbert to a claim brought by the sovereign itself, which was, of course, not the position in that case. The requirement to which the court's attention has been directed yesterday is a requirement which in my submission can only apply as part of the characterization exercise where the claim is not brought by the foreign state itself. And of course, both Williams and Humbert and Taylor were, of course, claims brought by a legal person distinct from the foreign government. And as part of the characterization exercise in that situation, Lord Mackay directed attention towards the question of whether those private claimants were, in any sense, acting as the means of asserting a sovereign right or a foreign tax law. And it was in that context that the unsatisfied claim language which the court has seen was used. But thinking that through, in my submission, that extra layer of analysis falls away when one looks at a claim brought by the foreign state itself. There, and I've just shown some examples from the authorities, one looks at the sovereignty test, pure and simple, as we have seen in the analyses from Ortiz and from Mbusugu. And I'm going to go back, in particular, to Mbusugu to look in a little more detail at what we learned from that about important questions applying to the facts in this case. So, the courts in the sovereign cases, the cases where there has been a sovereign claim, have consistently expressed themselves in terms of whether the claim amounts to the exercise or assertion of a sovereign right or fulfills a sovereign interest. There is no unsatisfied tax claim gloss on that test where the claimant is the state itself. And indeed the appellant points to no authority where the claimant state has been required to meet that test. That is merely, we say, a helpful touchstone to work out the true nature of the claim in a more complicated case where the claimant is a private person. So in other words, there is no, on the face of it, state involvement. And in my suggestion, Lord Mackay was simply directing attention to broader considerations that would have to be addressed when the court faced that slightly more complex exercise of working out the true nature of a claim which on its face was simply one being pursued by a private individual.
Well, see that, understand those submissions in relation to where a sovereign is making a claim. You would say, well, it plainly is an assertion of sovereign authority because you're claiming it qua sovereign, such as for tax. But in a situation where the sovereign has paid money away and then is reclaiming it.
That's the point that Dr. Mann made, isn't it? Because what Dr. Mann says in the famous article is that the position is different, where the claim by the sovereign is one which he, the sovereign, might just as easily make as an individual. And that's essentially, I don't, it may be that too much is being read into what Lord Mackay said in the Humbert. But my understanding of the point about the unsatisfied tax claim is it's said by the appellants, the fact that there isn't an unsatisfied tax claim, and I understand that's the debate about that, whether that's right or wrong, but assume for the moment there isn't, it is a demonstration that this claim is not a claim by the sovereign qua sovereign, it's a claim by the sovereign which might just as easily be made as an individual. I've been defrauded. I paid out money which I wouldn't have paid out by way of a refund if I hadn't been defrauded. And that's
responding first to the observations of my Lord Justice Phillips, and to be clear, there is no submission and has never been throughout this case that a sovereign, in principle, may not bring a claim in the courts of England. That was a debate about 200 years ago, but it was settled in the case law. So there's no debate that there are claims which foreign sovereigns may bring in this court. There are claims which foreign revenues or foreign tax departments may bring in this court. The question is, and the submission would be foolish if the respondents were putting it so broadly. That's of course not true. In this court hears many claims, both brought by and against sovereign states on a daily basis. If the appellant's submission is the more modest one that my Lord the Chancellor proposed, which is that, not that there, because we certainly heard it as a proposition that there is an absolute requirement in this case for the rule to be engaged, that there be an unsatisfied tax claim in Denmark. And then I was making the submission that that places too much weight by some considerable margin on the observations of Lord Mackay. If the submission is simply that one factor that the court may take into account is that there is in the appellant's, although not the respondent's submission on the facts, no unsatisfied tax claim in Denmark, that's not determinative, that is just one factor in the general mix, then as a matter of law, we do not probably have an argument on the scope of Williams and Humbert, but we certainly heard that has been put as an absolute, both in writing and orally, as an absolute requirement.
The reason why Lord Mackay said it was essential is that if there is no unsatisfied demand for tax outstanding, then by definition, SCAT or whoever it may be cannot be seeking to enforce a claim for tax, because there is no unsatisfied demand. So in that respect, simply as a matter of, that explains, to my way of thinking, why Lord Mackay said essential. And that is why I suspect you heard the submission being put as high as it was, because that's, could be said to be obvious.
I'm conscious that I can continue this train of thought for a minute or two and then break for the lunch break, or I'm very
suggest
conscious of the time.
I suggest you go away and have a think about the points that we've all raised and come back to it at 2:05.